Welcome back to KTN Prime. It's now time for the conversation. As hinted earlier, we'll be evaluating the push and pull within the judiciary, even as we evaluate the latest developments. Now, get this, in recent months, the judiciary has come under sharp scrutiny, with a section of legal practitioners calling for the resignation of Chief Justice Martha Koome and her fellow Supreme Court judges. Why is this? They accuse them of widespread graft in the judicial system. Now, this move has sparked numerous battles and has opened up Pandora's box and caused a domino effect of sorts. So I'm set to review some of the developments that have played out in the judiciary with learned friends who are joining me in studio. Allow me to introduce them. Kibe Mungai, a constitutional lawyer. Thank you so much for your time and karibu to our studios.
My pleasure.
Asante for your time. Equally joined by Dr. Maxwell Miawa, who's a scholar and constitutional lawyer. Karibu sana. It's a pleasure to have you with us.
Asante sana.
Well, we'll be looking towards, sort of shedding light on the push and pull within the judiciary. But let's just start with the very latest, where the Commission on Administrative Justice just last week summoned Chief Justice Martha Koome and 9 other members of the JSC over failure to publish complaints as per the statutory requirements. This coming weeks after the Ombudsman directed JSC to publicize all complaints filed against its officers. We have Charles Dulo, the Commission on Administrative Justice Chair, speaking on this particular matter. Let's just listen into the sentiments he shared last week Friday in regards to this matter.
Commission on Administrative Justice has today issued summons to the members of the Judicial Service Commission to compel their appearances before the Commission on the 24th March and 25th March, starting at 10 a.m. It should be noted that the Commission has in the recent past engaged the Judiciary and the JSC regarding the resolution of the publication of such complaints. Since 2019, to date, the Commission has received over 700 complaints of maladministration against the Judiciary, some of which have remained unsolved to date. As a creature of the Constitution, the Judiciary and JSC are required to comply with the Constitution and the law, which includes prompt, efficient, transparent, and accountable handling of the complaint.
Okay, sentiment shared by Charles Dulo just Friday, that's last week, in regards to the summons they passed to Chief Justice Martha Koome and other members of the Judicial Service Commission. It's proper to note that JSC, through its secretary, Winfrida Mokaya, dismissed this summons by the CAJ, insisting that they are misguided and unconstitutional. So I'd like us to begin on that particular point. Kibe Mungai, has the Ombudsman overstepped its mandate? Do they have the jurisdiction to issue summons to an independent body like JSC?
In many ways, it is unprecedented. And I was looking at the statute creating which they call the Commission on Administrative Justice, which is an act of parliament made under Article 59(5) of the Constitution. Now, there is nothing express that would suggest that first, the complaints relating to the judiciary, on the face of it, should be directed to the Judicial Service Commission and not to CAJ. So on the face of it, one would presume that if any Kenyan, for good or bad reasons, were to make those complaints before the Commission on Administrative Justice, that the same would be forwarded to JSC. Because one of the most important things under the Constitution is to ensure that you do not get unduly into the mandate of a fellow commission, so that the government can serve the people of Kenya. Okay. Because all the purpose of all commissions, the first one, by the way, the 3 important ones, is to defend the sovereignty of the people, constitutionalism, and to ensure that the rule of law is performing well. Therefore, one would presume that in fighting against them without a very clear mandate, that an independent commission like the JSC is to supervise by CAJ, that without express powers, one would have some discomfort with it. Because, as I say, before they came over now with these summons, and in fact to take it was that apart from just saying, can we look for a way to solve these problems, there is now an aggravation that we are even going to summon your commissioners to come and answer to these complaints, and failure to do that may lead to either imprisonment, may lead to fines. There's something untoward about it on the face of it.
Okay. Miawa, as you come in, talk to us about this push and pull between these institutions within the judiciary, because there's some who argue that this is an effort to enhance transparency in handling cases against judicial officers. From a different point of view, especially those affected judges, they say that this undermines the independence of the judiciary.
I think this institutional conflict is triggered perhaps by a misapprehension of the mandates of these two institutions. On the one hand, we have the Commission on Administrative Justice, which is a body created by an act of parliament or a statute. On the other, you have a constitutional commission charged with particular mandates, of which discipline, questions of conduct or misconduct regarding judges is domiciled in that institution called the Judicial Service Commission. But I think there is something that we have to read much more than the statutory underpinnings or any other undertones. For the first time, as my senior said, you have one commission, questioning another commission. And by the way, in my view, I think the Commission on Administrative Justice is an inferior body compared to the Judicial Service Commission. The Judicial Service Commission is a constitutional commission. The Commission on Administrative Justice is a statutory body. Okay? So that if one summons the other to be answerable to it, I think there is a constitutional conflict there. There is actually a serious constitutional conflict that has been raised by this issue, one commission summoning another commission. Yes, I do agree that we live in an era of accountability, constitutional accountability, where norms, rules, and institutions have to speak and are to govern our lives, our constitutional governance. But I think it must be within the black letter of the law, It is quite anomalous. It's actually quite strange that an inferior body can summon a superior body to go before it to answer particular questions of governance. And particularly the issue, the facts in issue here is a question to do with perhaps misconduct of judges, performance of judges, issues of discipline of judges. That cannot be the mandate of the Commission of Administrative Justice. That is clearly the Judicial Service Commission's work. Okay.
I would interject and say that when you look at Article 59 of the Constitution, though the CAJ, Commission on Administrative Justice, is created under an act of statute, but the law proceeds on to say it will have the same status as any other commissions under, I believe, Chapter 15 of the Constitution. So from a legal point of view, I don't think it is inferior. The bigger problem is one of them has a direct constitutional mandate, and which appears to be separate from the other mandate of the other. So where there is convergence in this conflict, that's where the problem arises. Because it's just like we live under what we call the doctrine of separation of power. And for example, they say that if you are parliament, you cannot exercise judicial powers. If you are the judiciary, you cannot exercise legislative power. And so is the executive. So that the president of Kenya cannot, if he hates you however much, he cannot get you arrested and you are taken straight to committee. You will have to go before a court of law, and only a judicial officer can take you to committee. So in the same way, one would expect that if the complaints on the face of it primarily relates to judicial officers, why should it be an issue for the Commission on Administrative Justice. That's where the problem begins.
So,
yeah. And I think that's perhaps the reason why one has got to read much more. You know, the emergent move of one institution, you know, of incursion into the mandate of another raises serious questions. Because first of all, who filed these 700 complaints with the ombudsperson, you know, over the years? If somebody had a problem with the judge, you know, the Judicial Service Commission is there. We also have a judiciary ombudsperson, by the way. There's also an ombudsperson within the institution of the judiciary. So that if the question or the complaints were not addressed by the JSC, there is still the ombudsperson who would have addressed. Why go to the national ombudsperson over a judicial matter? Why bring the matters of IEBC, for example, if it's an internal IEBC issue, for example, to the judiciary when you have a dispute resolution inbuilt and internal processes? There are serious questions here. I think somebody's overstepping their mandate.
So, do you hold the view that the JSC members should honor the summons, or is this a case of someone overstepping from where you sit?
I think the regular manner is when you disagree, because you see if summons have been issued, so that you do not aggravate the conflict and compound it more. You may need to challenge it in court, because if you are saying they do not have the power to do that, then the fair thing, the law says you go to the High Court. But of course that again is not the best of the issues, where you are having two bodies that should be serving the people of Kenya by exercising their distinct constitutional mandate, now having an internal war. It's a civil war, essentially, which cannot be a good thing for the country.
It's to the detriment of Kenyans, of course. Let's just expand this conversation to include the ouster of the 7 Supreme Court judges, because the High Court decision to halt JSC proceedings seeking the ouster of the 7 Supreme Court judges highlights the magnitude of the battle facing these top judges. The petitioners want them axed over alleged incompetence and misconduct in handling various cases. And I'd like to begin on this particular point, because the Supreme Court judges moved to court seeking the suspension of the JSC proceedings on the grounds that, you know, the Commission lacked the constitutional mandate to handle claims against them. What constitutional functions fall under the JSC mandate? Does JSC have the oversight authority over the Supreme Court? I think that's a big question here. What's your take on that?
First, my take would be that the JSC performs many functions when it comes to appointment of judges, but the most critical one is actually the protections of the independence of judges and the judiciary. It takes some role in the discipline of judges, and it also plays some role in the internal affairs, because it is like the commission that is responsible for the affairs of the judiciary. So it has certain executive functions within the body that is called the judiciary. Now, having said that, the vis-a-vis independent, the issue, for example, of appointment, the issue of discipline, as generally understood, is that every judge, particularly of the superior courts, namely the High Court and the courts of the status of the High Court, the Court of Appeal, and the Supreme Court, they are individuals. And their offices, each of them as an individual person, you are protected by the Constitution and vested with independence to make your decisions, whichever way it goes. So that even where you are sitting 3 or 5, as it is the quorum in the Supreme Court, you are still an individual. And when you make a decision, an inquiry must be made that have you misconducted yourself as a group? Misconduct is understood when you read the law that can only be misconduct or failure of an individual judge. So that the big problem that people are grappling with is having considered, and I concede, some judgments of the Supreme Court itself, I have had occasions to disagree with. For example, and we were just before in court today, and I was disagreeing very strongly with the decision that said that the president enjoys absolute immunity that was done in the BBI case, and even that was even equating the president to be some kind of a sovereign, which is an issue for the old law, equating the president to the King of England, when the Constitution expressly says that the people are the sovereign in Kenya. Now, there are those decisions that very many people disagree with. Okay. But what I have never fathomed is, if I disagree with that decision, did those judges misconduct themselves or did they fail? Because there is still a mechanism in which even the Supreme Court itself can review its decisions. If they are so horribly wrong, then they can be reviewed. And one of the intentions with my clients who are with the court today is that we shall ultimately get that decision overthrown. Okay. So I'm making the point that we disagree with very many decisions, but whether just disagreement with those decisions without evidence of corruptions, without the evidence of bad faith, that they should constitute grounds for the removal of any judge. And again, the bigger issue now also becomes when you target the entire institutions. You know, if you are to say that you have targeted the Supreme Court, it is the court that has the final decision making in terms of the judiciary and very many decisions. Minus that court, whether it will be vacant, assuming they were all to be removed, or if they were to be removed enough number to deny that quorum, it would mean effectively that the judiciary will not be able to operate as a judiciary. Remember, we've had the history in our country and in very many other countries that when you do not want democracy and accountable governance, then the first thing that you do away is the judiciary. Remember, in the 1980s, judges used to have security of tenure. This security of tenure was removed during the time of Matthew Guy Muli, so that we have a bad history that anything that on the face of it appears to shake the judiciary, one must look around and ask, is there something afoot? And why is the concern bigger? The concern here is bigger for two reasons quickly. Number one, the fact that Parliament, for all practical purposes, has been captured by the government of the day. So that as we stand in Kenya today, amongst the three institutions, executive, and then the judiciary and parliament, it is only the judiciary that has some autonomy and independence to stand up for the people of Kenya. Parliament, as we saw with the Gen Z revolts last year, is a completely captured institution that is no longer serving the Kenyan people. It's captured in a way that when they are told by executive jump, they retort. How high? We cannot have a situations whereby you get the same issue. And finally, which is a bigger problem to me, is that there is in the grapevine, and more than in the grapevine, that when you saw what happened with IEBC, that it took unduly long for it to be constituted. You see, when you want to trigger a constitutional crisis, then you go after important bodies like IEBC, you go to important bodies like the judiciary, you shake them in a way that you end up, because the removal of the Supreme Court effectively ensures that the constitutional order in Kenya will not be able to stand as it is envisaged from a structural point of view. And why is it a concern? The concern is this, that there could be an attempt to avoid a general elections in the year 2027, but the route to be able to do that, and I'll explain one of the days when you deal with the issue of IEBC, is by ensuring that there is what looks like a natural constitutional crisis that we would say, well, what could we do? It seems like we are in a cul-de-sac that on the face of it will be said has got nothing to do either with the government of the day or anything. So during times of crisis like this, I don't think much as I want accountable judges and what have you, that I want institutions to be shaken in a way that ultimately, the worst institution in Kenya, I'm sorry to say that, would be the executive. If somebody was to suddenly say that the worst institution is judiciary, I'll say, boss, wait for a minute. That doesn't look real.
Okay, Mungai. So just briefly, because we need to take a short break, perhaps add to the statements shared by Mungai. In retrospect, do you believe JSC has oversight of the Supreme Court?
The issue before the courts that have been taken by various judges before the court, before the High Court, has got nothing to do with the superintendents of the Supreme Court by any other body. The Constitution entitles everyone. I think this is perhaps a more objective view, a non-political view that I'm going to give. I'm not a politician. I don't make political statements. The Constitution entitles everybody to file a claim or a complaint against any judge as an individual judge, as a state officer. That claim can be framed either as misconduct, incompetence, or even on medical grounds or breach of the Constitution. One may look at it from any other perspective, but any other individual, any other ordinary Kenyan may frame a complaint before the Judicial Service Commission. The Judicial Service Commission has got the mandate to investigate complaints for removal of judges. It has the authority to appoint judges or to recommend appointment of judges, and also to investigate complaints relating to removal of judges. Any other individual Kenyan, including one who is not a lawyer, may frame a question and present it before the Judicial Service Commission as one that either involves incompetence or misconduct. I think the complaints that are before the JSC have been framed differently. And all of them relate to the removal of every judge as an individual, not the Supreme Court. In fact, the Constitution is far from that idea of removing an entire court. It is a complaint against each and every judge, particularizing the elements of that complaint. Now, then the question then becomes, of course, these judges have run back to court and raised these issues of whether they want to remove the entire court. It will subject the country into a constitutional crisis. I do not know the merits of such arguments, but I think the complainants had in their view, or their target, specific target was each and every other judge in relation to their conduct. In this particular case, the conduct relating to the decisions they made. And perhaps my colleague, who is my senior, I know he has argued prominent cases such as the Joy and others by the Attorney General. But judges have been removed, if our history serves as well. Judges have been removed for the reasons or for the way in which they made certain decisions. Whether you're talking about the Judges and Magistrate Vetting Board, some Court of Appeal judges, Justice Omolo, Justice, and other judges, if you don't go into their names, were removed because of the particular decisions they made, or particular statement they made during the hearing of the merits of a particular case. And that may go into question of either misconduct or incompetence. It has got nothing to do with the removal of an entire court, Yeah, we remember, for instance, that during the magistrate judges and magistrate vetting board, quite a number of Court of Appeal judges went home. And there was no such a question as a constitutional crisis, But I know there was a radical surgery at some point or another that recommended the removal of almost a greater number of judges in the High Court, and there was never a constitutional crisis. I think, in my view, the more objective thing to do, let us approach each and every complaint filed before the JSC on its merits and focus on each and every judge based on their conduct. All these judges will have an opportunity to respond before the JSC and before the High Court. And by the way, the judges could be right in going, because I know there are arguments out there that the High Court has got no mandate on questions to do with the investigation and removal of judges. It depends again on how the questions have been framed. If it raises issues to do with violation of the Constitution, violations of fundamental rights and freedom, the judges are right in approaching the court.
So let me ask you this just briefly. Can JSC entertain an omnibus complaint against the entire 7-judge bench? Or you said it's individual?
You may call it omnibus,
Yeah.
but I think in the omnibus complaint, the complaints touches on each and every judge individually, based on the collective decision that they made. Okay? So, I mean, the problem could have perhaps have been the person who filed the complaint before the JSC. It would have been proper, for instance, for him to file an individual separate complaint for each and every other judge. But I don't think that is fatal to the claim, to the complaint before the JSC, because there is no such thing as removal of a court or the disbandment of a court. The JSC doesn't have such power to disband a court. They don't have such power to remove an entire court. They only have power to remove each and every judge based on his or her individual conduct.
Okay.
I think I should add something
Yeah,
here.
briefly, before we take that break. Okay.
Number one, I think the law, first of all, we start with the vetting of judges. At least I defended Justice Nyamu. In my view, he was removed unfairly because of a decision that under the Constitution would be protected by the concept of independence of the judiciary.
Okay.
Now, but we must reckon with this, that during that time, it was never pretended that we were acting, strictly speaking, under the Constitution. What was happening is that we were just exercising political power to clean up the system. And that is why there was a provision, for example, that was saying the Attorney General of the day, the Chief Justice of the day were going to vacate their offices upon promulgation of the Constitution. And they did. Isheru left office. I believe Amos Wako also left office. And we had to hire a new Attorney General and Chief Justice. So that was an exercise of political power.
Okay.
We should not make it similar to what is happening. Number two is the fact that from the standpoint of law, you cannot say, for example, in the High Court, you have about 70, probably 100 judges. When you say you are targeting 6, the High Court, you cannot bring a crisis that the High Court would stop to do its business as the High Court. But the JSC has 7 judges.
Yes.
And to sit at all, you need a quorum of 5. So if you are to say that you have tribunals, not even against 7, against 3, it would effectively means that you do not have a Supreme Court in Kenya. The makers of the constitutions of Kenya never intended to have such a serious gap under the constitutions. And let us remember that just the other day when Rigathi Gachagua was being removed from his office as deputy president, it was done within 8 hours of our decisions being passed by Senate. Because we were told that you cannot even countenance situations whereby you had any gap, although the constitutions of Kenya actually envisages a situations whereby you had even up to 60 days.
Okay.
But they decided to do it within a few hours. So that during a time when you have 60 days, and you say we cannot have a vacuum for more than 1 day, okay? You are the same people saying that you want to trigger a scenario in which Kenya will not have a Supreme Court. You cannot be said to be a very angelic and people who mean well for the country.
Okay.
Yeah, it's hard to fathom that.
It might be double speak, yeah?
Yes.
Anyway, let's take a short break. As we come back, we continue with our deliberations right here in studio as we evaluate the state of the judiciary, bearing in mind the recent push and pull we've witnessed within the independent arm of government. As we come back, I'll be putting my learned friends to task to perhaps tell us if a judge can be removed over a ruling they were not involved in. Equally, another issue that needs interpretation is whether JSC's actions violate the doctrine of judicial independence. This and other issues will be canvassed right after this break. Stay with us.